He's sick.
Oh my goodness. Welcome, welcome, everyone. I know we can't see your faces, but it's amazing to see your faces. I know we've been dark for a few weeks, so excited to have you with us. Mike, good to see you. Good afternoon.
Hi. Thank you very much. It's good to see everybody.
I am going to go ahead. Actually, let me give it a couple of seconds while more people come in.
Okay,
and then
sure.
We'll get started.
So thanks for your patience. I know for those of you who have been attending this on a weekly basis, you're expecting us in the month of January. Unfortunately, I caught COVID, out sick, plus I had jury duty, and GB had issues, and now he's out sick. So I'm glad to be back to present to all of you.
You know what I'll say? We've had a really good record, though. Like, it's been a strong 2 years and or a few years, actually, right?
Right. So thanks for coming back to us. Appreciate it.
Yeah. Thank you, everyone, for your patience. Mike, I'm going to go ahead and share my screen. If you wouldn't mind, let me know when you can see it.
It's up.
Okay. Oh, I just got a big. Can you see my screen? My slide?
Yes.
Okay. Good. Okay, everyone. Looks like our numbers are steadying. So let me go ahead and jump into the intro. Good afternoon, everyone. My name is Lauren Simpson. Welcome. We're excited to have you. I am with the SBDC. The SBDC, or the Small Business Development Center, is a national program with over 1,000 locations across the country. And we offer no-cost services to local small businesses. Now, our services are at no cost to you because your tax dollars have already taken care of all of our fees. For the Los Angeles network, we serve businesses throughout the Los Angeles, Santa Barbara, and Ventura counties. So if you are within any of those counties, again, Los Angeles, Santa Barbara, or Ventura, please be sure to get in contact with one of our local offices. And you can see those represented on the map in front of you. Here's why you need to get in contact with us. We offer no cost business advising. So that means you're able to sit one-on-one with one of our business experts. Currently, you're sitting one-on-one via Zoom or phone call with one of our business experts. And those experts range in the arenas of marketing and finance, taxes. If you're looking to go from being a handyman to construction, honestly, you name it, we've got resources for you. We also offer virtual trainings, much like the comprehensive workshop you have joined today. So please get in contact with us today. We'd love to get started. You can reach us by phone, 866-588-7232. Again, 866-588-7232. Or if you'd rather go online, smallbizla.org/new client. If you've reached us outside of our service area, so you are a local business outside of the Los Angeles, Santa Barbara, Ventura counties, please go to americassbdc.org/find your SBDC. Mike, I'm going to quickly stop my share. Before you jump into your presentation, I wanted to quickly share the new grant program we have going on. Let me navigate to it really quickly. All right, let me share my screen one more time. Okay, everyone, I think you heard it first here. We have the County of Los Angeles has launched the Economic Opportunity Grant Program. We are one of the facilitators. And so I wanted to share with you the landing page. You can see the URL here on the screen in front of you. I will also copy and paste the URL into the chat so you can click it there. But here's the landing page. You'll just scroll down. You'll see that, again, we're in phase 1 for micro businesses. There are some stipulations related to phase 1. And so if I scroll, you'll see the information here. You'll see we have tabs for preparation as well as application help. There are 2 phases. Currently, phase 1 is open. Phase 2 will be available or open February 23rd. So in a few weeks, actually. You'll just scroll down. Something that I really wanted to share was that here's your homepage. If you go to prepare to apply, you'll just keep scrolling. You'll see that application checklist, keep scrolling, eligibility guidelines. We're going to keep scrolling, Mike. Ineligibility, ineligible entities. And I'll keep going. Required documents. Again, there's checklists for phases 1 and 2. Here's concentration on phase 2. Note that phase 2 includes nonprofit. And then we're here to help. So these are really good buttons for you all. You'll see that there are application guides, there's phone support, here's that number here, there is email support, and then tech support is for once you've actually gone into the application. So you've started an application and you're having some technical difficulties, and you'll click this button here. If I go to the Get Help tab right here up the top, we'll just scroll down. Again, we will have info sessions. I actually was just on an info session. So we have info sessions running weekly through the end of March. So through the month of March, they are Mondays and Wednesdays at noon in Spanish, and then Tuesdays and Thursdays at noon in English. So we just completed our English session. If you have any questions and you want to sit in one of those live info sessions, please click here and you'll be able to register and come on and join us. And then if you'd rather just check out our video tutorials, they're here. There's application guides located here and live support. Mike, before I hand it over to you really quickly, if we go back to the homepage, you can translate it into several different languages. You can see them represented on this sidebar. Can you see that, Mike, on the left here? Okay.
Yes. Yeah.
Perfect. So we have several. If I keep scrolling, of course, there's we've got Spanish, we've got honestly, you name it, we've got it. And if you don't see it represented here, just reach out to us. We have 14 different language translations that we can assist you in. So with that, Mike, I have said a mouthful. I'm going to enter those links into the chat for everyone. Otherwise, I'm going to kick it over to you. Good afternoon again.
Well, thank you so much. And I'm so glad to be here. And for those who didn't hear it, I'm glad to be back. I was out on jury duty, then I had COVID, and BB's out sick now. So that's what happened. Now, Lauren, quick question about this first phase.
Sure.
What's the value of the grant?
$2,500.
Okay. And what is the threshold for revenue for those who want to take advantage of it?
Oh, I'm sorry, Mike, say that one more time.
The revenue threshold, the revenue limit.
50,000. So these are for micro businesses. Phase 1 is micro businesses. Phase 2 is going to be for small businesses and nonprofits. So phase 2, the threshold is higher. I will link it here in the chat and you guys can, dive deeper into it. Currently on our info sessions, Mike, we are only addressing phase 1. Once we past the 23rd of February, we will dive into phase 2. But if you have any questions related to phase 2, there is a sign-up sheet. So if you want additional information, just sign up there. Again, everything is accessible via the website. I keep talking about the website. Let me go ahead and put it in the chat.
Okay. So to be clear, phase 1 is open. I think it opened on January 25th. For those of you who want help, attend the info sessions. And there are advisors, all the advisors getting training, including myself. I'll get that training on Friday to help you out. Yep. Okay. So I'm going to go forward with my presentation. I'm going to be talking about small claims court. Now, I do realize that maybe many of you have never filed a claim in court. And maybe you have not participated in a small claims case. Perhaps you're seeing maybe a TV show where small claims are brought. And it's kind of like that, although those shows are meant for entertainment. That Judy is entertainment. She's very well paid for what she does. Very well paid. Much of us who have our own business, including myself, went into issues. It happens. It's natural. You're going to run into problems with concerns. I've been an advisor with the SBDC since 2016. I've been a professional advisor since 2011. I've been in business for decades. I have been a CFO and controller. I have been involved in court cases. My companies have been sued, we have sued other companies. We won some, we lost some. Things happen during business. So you want to be able to protect yourself, number one. Number two, defend yourself. And number three, go ahead and go forward with a claim if it's appropriate for you. And you might want to consider going after a small claim if it's right for you. Now, most people have not been through this process. I'll do my best to try to explain it. Certainly, you can ask questions, put them in the Q&A, not in the chat room, and let's please keep the discussion on topic. So, in small claims court, it allows you to sue a person, business, or a government agency that you think owes you money, okay? Generally, you can only sue for up to $10,000 in small claims court for individuals, up to $5,000 if you're a business. And beyond those limits, you have to go to superior court. Now, you can ask a lawyer for advice before you go to court, but you cannot have a lawyer with you in the courtroom. You're representing yourself in the courtroom, and the defendant, if the defendant shows up, will represent themselves. And the defendant can also countersue you, and that happens quite a bit. There are forms available at a website, at the California Courts Forums here, and I'm going to be providing this presentation to Lauren. If you write to her, she'll go ahead and make it available. And there's a particular form that you fill out in order to submit a claim. So what is small claims court? It's a simple court. We try and resolve disputes quickly and quickly. The procedure is much simpler than if you go to superior court. Oftentimes in superior court, you have a plaintiff's attorney and a defense attorney, oftentimes as a jury, and it can get to be really expensive and very, very time consuming. For those of you who have been through it, you know what I'm talking about. Okay, so this is meant for smaller, simpler cases. For example, maybe your landlord didn't return your security deposit, or a client didn't pay you for the work that you completed. So in a court case, and I know this might be very basic, but in a court case, the person bringing the suit in a civil case is called the plaintiff, and the person that is being sued is called the defendant. Now, if you're countersued, you're still known as the plaintiff. There's a particular form you fill out to file for a small claims case. And I'm going to go do that later in the presentation. And it's filed with the court clerk at the court that you're going to want the case to be heard. There's a couple of key points to remember when filling out the form. You have to name the defendant correctly. If you're suing a business, like an LLC, you have to name the LLC. If you're suing an individual who has a DBA, then you have to list the DBA. You have to be very specific, in particular, as to who is named as the plaintiff, yourself, or the defendant, or defendants. Okay, and be sure you submit the correct form. It's an SC 100. There's a whole list of forms available, which I'm not going to go through relating to court cases. I have them listed here as a link. Now, I'm curious, for those of you who have been through a small claims case, could you please just say yes and no in the chat room? I'd be curious to see how many people have been through it, either as a plaintiff or a defendant. And I see something in the chat room about somebody owes you $50,000. That doesn't go to small claims. That's well beyond the limit. Okay, keep in mind, the limit for small claims for businesses is $5,000. Individuals is $10,000. Keep that in mind. And that's reiterated here. Now, for each additional case filed in the same calendar year, you can only sue for $2,500 or less. Okay, for businesses, including partnerships, LLCs, LPs, or corporations, you can file 2 cases each year for as much as $5,000. Keep that in mind. And can you sue for more than the maximum? No, you cannot sue for more than the maximum. If you want to bring it to Superior Court, you can. Are there time limits? Yeah, If your case isn't filed on time, the judge can dismiss it. There should be a written contract, and the time limit is 4 years. There's something called the statute of frauds. And the statute of fraud means essentially that everything must be in writing. Do not work off a handshake. I don't care how long you've known someone. I've known people for 20, 30 years, and I still didn't get paid in one particular case. So always have something in writing. For an oral contract, it's 2 years from the date the contract was broken, but keep in mind, because of the statute of frauds, if you can't produce a writing, then you most likely will have a lot of difficulty proving your case. So for personal injury, it's 2 years from the date of injury or from the date you discovered you were injured, which might be a year or two later. For property damages, it's 3 years from the date the damage happened, and for fraud, 3 years from the date you discovered you were defrauded. So keep in mind these time frames. 4 years for written contract, 2 years for an old contract, 2 years for personal injury, 3 years for property damage, 3 years from the date you discovered you were defrauded. So if 5 years has passed, I'm sorry, you're out of luck. You will not be able to bring the case. Now, what's the cost? So it depends on the amount of your claim. $30 for a claim up to $1,500. $50 for a claim of $1,500 to $5,000. $75 for a claim of $5,000 to $10,000. But if you're a business, you can only go up to $5,000. So the fees aren't expensive. The fees can be waived, by the way. If you can't afford these fees, there's a form you can fill out to waive the fees. Now, where you file it, it's called venue. And you want to file it where the damage or the injury occurred. And there's a court locator that you can check to determine what might be the appropriate court to go to. It's called a venue. That's the location where the case is to be heard. It's called venue. Okay. And if you sue in the wrong court, the judge may refuse to hear the case. There are 12 small claims courts in the county of Los Angeles. You can only file your case at one court. So how do you choose the right court location? You can file in the court nearest to where the person you're suing lives or where the business is located. If your case involves a contract, you can file at the court nearest to where the contract was signed by the defendant. And remember, in my opinion, everything should be in writing. And that writing should indicate everyone's addresses, because if you don't have it in writing, it's going to be really hard to prove your case. You can also file with the contract was supposed to be carried out, as long as they are able to be served in California. If your case involves property damage or personal injury, you can file in the court nearest to where the damage or injury occurred. Now, court papers must be served to the defendant in California, unless the case involved real estate in California or a vehicle accident on a California highway. There may be one court to choose from, so choose the right court by going to the filing court locator. I have a question. If a defendant countersues you, does she have to bring that case to small claims court? Yes. Or will that countersuit case be held in civil court? No. Are defendants who choose a countersuit entitled to be represented by a lawyer? No. And the countersuit cannot exceed the limit. No one can bring in a lawyer to represent the defense of the place. So those are good questions, so thank you for asking them. Let me go down. So I already went over the fees, okay? But if you can't afford the fee, there's a form you can fill out to get a fee waiver, okay? And with a fee waiver, you won't have to pay for certified copies, service to process fees, court reporter fees, and most other costs. And the information you put on the fee waiver form is confidential. It's not going to be released to anybody. So how soon is the court date? Well, it depends, right? And everything was extended out during COVID. I mean, people were waiting months for cases to go. They're still waiting in some cases. But generally, a court hearing should be scheduled within 20 to 70 days. and it may be extended by the court. Make sure you request a court date that allows you enough time to serve the court papers to the defendant. Because if you do not serve the court papers to the defendant, then the case will be thrown out. They have to have notice of the case. And it's called proof of service. There's a particular form that you fill out that you must deliver to the defendant. And if you don't have proof of that service, then you will not be able to go forward with your case will be thrown out. Now, when it comes to a business, the corporation LLC, I think we've consistently told you, you must have the name of a registered agent on the form that you file with the California Secretary of State, public record. The purpose of a registered agent, also known as agent for service of process, what we're talking about here, agent for service of process, that individual or that corporation or business gets the notice. So I always recommend you use a professional registered agent. Otherwise, the notice is coming to your residence. So when you form an LLC, corporation or partnership, and you register with the California Secretary of State, when you fill out the form, whether it's an LLC 1 or articles of incorporation, my recommendation is to engage a registered agent first, who will take lawsuits on behalf of the entity. And is their physical address that is listed at the California Secretary of State site. And you can change your registered agent by filing a statement of information with the California Secretary of State. It costs $20. Okay. So how do you notify the other party? You can file a postponement if you haven't done it on time, and that's an SC 150. Okay. If you are the plaintiff, if you had and you have had the defendant served, or you are the defendant and you want to postpone the court date, you get these other forms, and then you make a copy for all the other plaintiffs and defendants in the case. And you have someone over 18 years of age and not a party to the case drop a copy of the mail to all the plaintiffs and defendants, and complete the proof of service by mail. If you don't have this proof of service by mail, your case is not going to go forward. Okay, and then you give the postponer form that you completed in the proof of service back to the court. That's how that works. Can a defendant sue you? Yes, the person you're suing can countersue you. They do this by filling out something called an SC 120. So the original case is filed with an SC 100, it's filed claims 100 form. Then the countersuit is filled out by filing an SC 120. So if you are sued, you can countersue by filling out this SC 120 form. And can you propose to postpone the date? Yes, we just went through it. There's another form. It's all about forms. An SC 150 doesn't cost any money. If you have served the defendant or you are the defendant, you can request a proponent and pay a $10 fee. Okay. The request for postponement must be filed at least 10 days prior to the court hearing. Okay, and the court will only grant one postponement for plaintiff and defendant. If you are the plaintiff and you have not had your court papers served on the defendant, you can go ahead and file the postponement and then serve it. So I think it's a question. As I understand, collecting from corporations, even if you win, is often impossible because the corporation may not be financially viable. Is there any way you can find how the financial health of the company before you file against it? You can do an asset search. You would have to hire someone to do an asset search. Yes, you can. And there's publicly available records if it's a public corporation, because they have to file with the SEC. There's other information that's available through private databases such as Dun & Bradstreet. So yes, you can find out some information. Now, because we're in COVID times and it's still part of it, there are special rules in place for COVID-19 rental date debt cases, okay? And I'm not going to go into all of these details concerning rental debt cases, My recommendation is if you are suing a tenant for COVID-19 rental debt, or you are being sued for rental debt, then you contact a real estate attorney that specializes in rentals and work with them. Now, they can't represent you in court, but they can give you advice and guidance. This is a very complicated topic, and this goes well beyond what I can provide today. And I'm actually not an expert in this area. Now, keep in mind, you can't have a lawyer represent you. And you must collect the money if you win the case. The court does not do it for you, okay? If you start the case, you can't appeal if you lose the case. The judge's decision is final. This is not a superior court case. This is a small claims case. So there is no appeal if you lose the case, if you started it. You can appeal if you are sued and the other side sues you back and you lose. So keep that in mind. But if you started the case, you can't appeal. Now, if you want to open a case in civil court, you can, but that means you're not bringing the case in small claims court. One or the other. You have to make a choice. Now, there's some special rules associated with attorneys and their fees, suits against local governments and healthcare providers. I'll go through those right now. So let's do it. Let's go for it. So with attorney disputes, oftentimes there's an agreement between you and an attorney, or if you are an attorney, and if you are an attorney, please let me know, and let me know any input in regards to what I'm presenting today. So oftentimes there's agreement, an attorney-client agreement, and that attorney-client agreement has an arbitration clause, and you must go to arbitration based upon that agreement, okay? If you're the client, you can also say you want to use arbitration before going to court, and the attorney has to use arbitration. At arbitration, the arbitrator will make a decision called a notice of award. Their decision will be permanent, binding. That's it, binding. If and when, immediately, if the attorney and client both agreed in writing after the disagreement started, that arbitration would be binding. And 30 days after the arbitration decision is mailed, neither the client or attorney has opened a court case to let a judge know they disagree with the decision. So just keep that in mind. If you go to arbitration, it's binding so long as these conditions are met. If you disagree with the arbitrator's decision and did not sign anything saying was binding, you must start a court case within 30 days of receiving the decision, or else the decision will become final. So keep that in mind. And oftentimes, not just attorneys, oftentimes with arbitration clauses in agreements through various service providers. Now, can you sue the government agencies? Not the federal government. You cannot sue the federal government in small claims court. That is not permitted. But you can sue a governmental agency from the state of California. But first, you have to turn in an administrative claim before you file a small claims case. And there's strict deadlines associated with the agency. If the agency doesn't answer, it doesn't agree to pay you after you turn in your claim, there are also strict deadlines called statutes of limitations to start the case against them in small claims court. And you have to be sure you're suing the right agency. At every level of government, city, county, state, federal for that matter, there's numerous departments and agencies. I can't tell you how many agencies the state of California has. Make sure that you're suing the right agency. Oftentimes it's confusing. People forget we have two agencies through the state of California for tax laws, multiple agencies, but the two main ones are the Franchise Tax Board and what used to be known as the Board of Equalization, now the CDTFA. The CDTFA collects sales and use taxes. The Franchise Tax Board collects income taxes. And that's just two of numerous agencies under the state of California. And the county has agencies and the cities have agencies. So What do? If you want to sue against the government? Well, fill out a claim form. Many have them online at the agency. And there is a site you can go to if you're suing the state of California. They have a government claims program site. If you're suing a city or a county, you have to contact the city or county agency to find out how to send in your claim. Okay. And there's a deadline in regards to these claims filed with these agencies. 6 months from the injury, you're suing about an injury to you or damage to something you own. 1 year from the date a contract was broken or your real estate was damaged. And there's some exceptions here. Again, my recommendation is to always talk to a lawyer with these situations. That's because they're complicated. So the government has 45 days to get back to you about your claim. If the government denies your claim, you have 6 months from the date they mailed the rejection to file a small claims case. If the government doesn't respond by the 45-day deadline, you have generally up to 2 years to start a case from the injury date, but you should think about filing a claim right away. If you are not 100% clear about your deadline to file, talk to a lawyer. Always get the appropriate advice, because these deadlines can be confusing and your case might be confused. So get the advice you need, not to move forward. And someone might say, you know what? I don't think you really have a good case here. You might not want to go do the effort. There's a question. Let's see what that is. Do the same COVID rental laws about bringing cases to small claims court also apply to commercial rental leases? Yes. But again, I'm not a real estate attorney. I'm going to highly recommend that you contact a real estate attorney, because there's differences with regards to the rental rules for commercial versus residents in LA County, for example. LA County recently extended the prohibition against evictions to the end of March for residents, individuals. But I do not believe that that is in place for commercial tenants, but I could be wrong about that. Okay, you want to sue the County of Los Angeles, Taisha? Is it below the threshold? Then first you have to determine what agency within the county you want to sue, and then file a claim against that agency with that agency and take it from there. Is there a recording available for this webinar? Yes, because Lauren has it posted on a YouTube channel. Lauren, perhaps you can go ahead and provide that link in the chat room. So when it comes to healthcare providers, you have to let the provider know you plan to sue. You can't just sue them. You have to let them know. You have to let them know in writing at least 90 days before you sue. It's called giving notice. Your notice must tell them the legal reason you're suing, what your injuries are, and what losses you have. There is no court form to use. You must serve the notice on the provider following specific rules. Again, this is complicated, especially when it comes to healthcare claims. I'm going to highly recommend you speak to a lawyer that specializes in healthcare claims before you do this, because you're going to need an expert witness. If you're suing about the care or treatment you receive, you will almost always need an expert witness. And expert witnesses are usually very expensive. And if you win your case, you only get those fees back if the judge orders it. You may not get those fees back even if you win. You'll need to prove in court that what the healthcare provider did in your case did not meet a standard of care. Okay? And you need an expert to say what the standards are. That way your healthcare provider did or didn't meet these standards, and that caused your injury. Always, always, always talk to a lawyer that understands the particular case you're trying to bring. Okay? Because medical malpractice lawsuits are usually very complicated. From there. So how much money can you ask for? You want to understand these questions, right? How much money can you ask for? If you have a legal reason for suing, who should you sue, and how do you find them? Always know who you sue.
Can you all message me in the chat and let me know if you are seeing that mic is frozen? Okay, let's give him a couple of minutes and he'll be right back. Thank you, everyone. Please, if you have any questions, go ahead and put those into the Q&A. If you would like to contact Mike because you have a specific question that he might not be covering today, I will put my email into the chat. Just shoot me a note and I will be sure that it gets to him or GB for answers. Thank you. Mike will be right back.
Sorry, I'm back. I had a technical problem. Can you hear me? Apologize for that. I'll go back to where I was. 1 minute, please.
Hey, Mike, just a quick heads up. I went ahead and put my email into the chat in case anyone in our audience has like a specific question related to a topic you aren't covering today.
Appreciate it. Let me go forward here. So I was on this slide here. There are limits. Know the limits. Now, sometimes you can ask for penalties. So in the case of a security deposits or a bounce check, you might get some penalties. Here's an example. Your friend borrowed $5,000. They agreed to pay you $100 a month. They stopped the payment and missed 2 payments. So now they owe you $200. You want to sue them for the entire $5,000 amount. You can't do that. You can only sue them for the missed payments, which in this case is $200. Unless your agreement with them says something else. And again, everything should be in writing. You can sue them for the missed payments and then sue them again if they miss more payments. Or wait until the end of the loan payments and sue for the full amount if they haven't paid you. Okay? Even if it's your friend, have a loan agreement in place. Now, what do you do if you want something other than money? Well, small claims cases are not about something other than money. It's about money. It's not to go in there and ask the judge to order someone to do something and not do something. That's inappropriate. Now, you might be able to ask for money as a substitute for something that someone did. That's okay. But if you want to ask the judge to enforce an injunction of some sort, then no, small claims is not where you go. You go to civil court, you go to superior court. So here's an example. A neighbor has put a fence on your property and you want them to take it down. You'd also be okay with them leaving the fence where it is if they pay you $9,000. Now, I don't know how many of you would take that deal, but I might consider that $9,000 for a fence. However, depends on how far the fence is approaching on the property. If the value of the property exceeds for what they're essentially taking, exceeds $9,000, then no, I'm not going to be so happy about that. So if I want to force them to take the fence down, I can't bring the claim to small claims court. I have to bring the claim in superior court. But if it's a few inches and they're willing to pay $9,000, I can get the court to order $9,000, but seriously consider it. Okay, remember, this is not a business suing anyone. This is an individual, a homeowner. There's another example. The breakups happen. So you're an ex-breakup and you want that barbecue grill back. You love that barbecue grill. But your ex is saying, nope, can't have it. And I'm keeping it. So you say, you bring the small claims court. You want that grill. The judge cannot make your ex give you the grill. The judge can't order that. But you could ask the judge to have your ex pay you for the fair market value of that grill, whatever that might be. It's not going to be the original value. it's going to be the fair market value. So you'll have to prove what the fair market value of that is. You always have to bring proof, evidence to support your claim. Go from there. So you have to have a legal reason as to why you're bringing the claim. Or if you're being sued, the plaintiff has to show to the judge a legal reason. Now, it may be different from the reason she feels someone owes you money. So before you start your court case, learn whether there's a legal reason the other side owes you money and what the reason is. So there's lots of different legal reasons that someone could be at fault and owe you money. You can do a lot of research on this. There's something called a small claims advisor. There's a link here to common situations. There's numerous law libraries. Just do the research. So there's an example. A customer refuses to pay for a custom order. So a customer orders, this is a real case. I had this spoke to this person about a month ago. He built servers. So a customer ordered a custom built server. And he took delivery at his place of business. Now the customer doesn't want it. Customer is saying, nope, not going to pay you. It was late. And he's saying, no, it's not late. He goes, yes, I wanted it by this date. And it was like a day too late. So the customer changed their mind because I'm not taking delivery of that server. But my client had already paid the supplier. And so what can you do about it? I said, bring a small claims court. Now you can only go up to $5,000 as you're a business, but it's worth giving it a shot. Fill out the forms, bring the small claims. Let's see what happens. Oftentimes people don't show up. If they don't show up at the hearing, then you win by default. So is it worth it to fill out the form and go after the money for up to $5,000? Or $10,000 if you're an individual? Maybe. Depends on your situation. But the client has to prove the order was placed and delivered to the specifications detailed in writing, and it was in a timely manner. I think it was a day or two late. And there was no defect in the product or missing components, missing software, and there wasn't. I said, do you want it? Do you need that server for your own business? I said, I can use it, but I'd rather get the money. I said, then go for it. File the claim. What do you have to lose? So to prepare for court, you can appear by telephone. That happened during COVID. You have to provide documentation 10 days prior to hearing. So you have to prepare evidence. And the evidence is all written documents, any videos, any photographs, any communications, whether it's text or email, any witnesses, anything that you have to prove that you are in the right legally, you should bring to court. Now, they are doing in-person hearings, just like you see on TV, and you go up there in front of the judge and you present the case, and the judge will ask you some questions. They'll ask you for your evidence. Then the judge will ask the defense, the defendant, their version of what happened if they show up to the case. And of course, you have to have proof of service before you do this. And if the judge rules in your favor, you'll know later. He or she may not rule immediately. They may send you a notice later or take it under advice. But you should bring all the appropriate evidence, document, and bring multiple copies of the evidence so that the defendant can have a copy of it and the judge can have a copy of it. You shouldn't just bring one copy, okay? And so receipts, canceled checks that prove your own money, bills, repair estimates, photos, videos, written contracts, agreements, other documents, and witnesses. And you have your 15 minutes of fame to prove your case. The other side goes. If they show up, and if you win, it's not over, because then you need to collect it. But at least you have a win. And if you lose, then you spend some money collecting all this data, filing the fees. Or if you are being sued and you lose, well, you have a legal and moral obligation to pay. Now, LA has something called a turbo court, the no-cost service that provides small claims court. Unlawful detainer is tenant evictions. Unlawful detainer litigants an opportunity to explore settlement options. There's a link here to this, okay? Now, each plaintiff and defendant must now register for this if they get a notice. And I'm going to show you what that notice is. And it's to make the system work faster and maybe come to a resolution without actually even going to a trial. So if all parties reach a resolutions, litigants may not have to appear at the hearing or trial date. It's an online dispute resolution feature, ODR. That's what it's about. Go back a little bit. So if the judge orders the other side to pay you, the other side has the defendant 30 days to challenge the decision. If they don't, they're supposed to pay you right away. Does it happen? No. Oftentimes it doesn't happen. If they don't pay you right away, they must send you information about what they own, where they work, and where they bank. You can use this information to try to collect the money. The court does not collect money on your behalf. You have to wait 30 days to collect your money after you're handed or mailed the notice of entry and judgment. That's what it's called, the notice of entry and judgment. That's what you're going to get, collect your money, if the other side doesn't pay you on their own. The 30-day wait is to allow the other side to appeal that they don't. If you lose in court, you're not going to get that appeal. That's not going to happen. Okay? If the other side pays you, you must let the court know. If the other side pays you, you need to fill out something called satisfaction of judgment. If the other side doesn't pay you, you need to go forward with trying to collect the money, in which case you hire a debt collector to collect the money. Okay. If the other side doesn't appeal, ask to cancel, pay you within 30 days, and need to send you a judgment, a statement of assets. Oftentimes this doesn't happen, so you'll have to hire a debt collector to go after the money. This is the notice that you will get if the court wants you to go to the online dispute resolution process. You get this, you have to go to that process. Now, this is the form. Before I go to the form, what about contractors? I'm not sure what you're meaning. Contractors can be sued and contractors can sue others. Not a problem. Rhonda, what about having the losing defendant pay for your court costs? I did that in the past. It depends. The judge does not have to allow for court costs. Up to the judge. In your server example, if the customer could prove your client was late in delivery, can the customer countersue? Yes, the customer can countersue for failure to deliver. Well, it depends. Did they suffer monetary damage? Maybe they had to go out and buy a more expensive server to meet a demand that they had to meet an order or something that they had to do. In which case, yes, they can countersue, because if that server was not delivered on time, costing them additional money. So it depends on the circumstances of the case. So countersuits are allowed, yes. So I believe I answered all those questions. The actual form to fill out is called an SC-100. And here we have an example of a plaintiff. That plaintiff is Jane Doe, doing business as Acapulco Restaurant on Main Street in Los Angeles, okay? Now notice, check here if there are more than two plaintiffs. In this case, there is not, but if there is an additional form. Check here if the plaintiff is listed above as doing business under a fictitious business name. In this case, they are, so that should be checked off, okay? Then the second part of the form is asking for the name of the defendant. In this case, it's an individual named John Smith on White Oak Avenue in Los Angeles. Okay, if there's a mailing address, it'd be separate. If it's a corporation, LLC, a public entity, you list the agent for service of process, which is listed on the California Secretary of State business name search portal. Okay, and down here, you list the amount that you're claiming. okay? And notice a claim for COVID-19 rental debt cannot be made on this form. There's a different form, the SC 500. This is an SC 100. And why does the defendant owe them money? Why is there a lawsuit going on? Well, in this case, the defendant, who is an individual, the defendant did not pay the plaintiff for catering a dinner party. Okay, so the defendant is John Smith, who's a homeowner who hired this restaurant, Jane Doe, doing business as Acapulco Restaurant. Okay, and the defendant did not pay the restaurant for catering a dinner party. Now, we don't know why. There could be a very good reason why this person did not pay for it, but that person has an opportunity to respond to the case and presenting their case to the judge, and it's up to the judge to decide whether or not this $1,800 has to be paid to the plaintiff, or the defendant can countersue saying that plaintiff didn't perform appropriately and he had to cancel the dinner party and bring in somebody else at a later time at a higher cost. So it just depends on the particular case. Sometimes these descriptions can be very long and you can add additional pages to explain your case. Okay, and notice, since this is a DBA, the restaurant is a DBA, this form also has to be attached, a C-103, listing the DBA, any address, and the business name, state number, the FBN DBA number, and when it expires. Okay, so that's that form for the filing, and this is the proof of service. So after the filing is made, proof of service has to be made upon the individual or the business. This is the form. There are process servers that you can hire to go ahead and submit the proof of service, and then you have to provide the proof of service to the court. And it's a relatively simple form, but it must be filled out, or else your case cannot go forward to the judge. All right, and the server must be 18 years old, right? And all the documents must be provided, and it must be served to someone who is over 18. It can't be given to a child. That doesn't suffice. And the person providing proof of service has to fill this out. Okay, and again, there's a bunch of information you have to fill out here. Okay. And that concludes my presentation on small claims. I'm going to go back to the top. I'm going to see if there's any more questions. Okay, I believe I answered all the questions. In the chat room. I don't see anything in the chat room. So with that, I don't have anything else to present today. We're coming close to the end of the hour. I'll give it another minute. Any other questions concerning this? Remember, don't give up. If someone owes you money, you feel you're in the right and you can prove it, and you might want to consider going to small claims. I've now shown you forms to fill out, and it might be worth considering. But for a significant sum of money, you might want to check with an attorney first before you go forward with the process. Lauren, I don't hear any more questions. Let's see. How do you contact me? I'm an advisor along with, I think we have 200 advisors in the network. By the way, disclaimer, we cannot represent you. We do not handle legal claims. We do have attorneys. I have a law degree, okay? We can give you general advice, but we're not going to represent you in court. We'll always refer you out to an attorney. Any other questions? Can we cover small? Yes. Can we cover small business insurances? I have an entire workshop written up just for insurance, which we can do next week.
Mike, there's one more question in the chat. What about having the losing defendant pay for your court costs? I did that
on
in
the judge.
past. Okay.
Depends on the judge. Okay. All right, then I'm going to wish everybody a good day. Thank you so much for your time. Thank you, Lauren. And God willing, we'll all be back next week. Bye now.